So far with this restructuring process, I've talked a little bit about what it is. I've gone through the eligibility requirements, and now I just want to go through this restructuring process itself. Okay, now I said at the start that I would treat that as independent to the plan, and we'll come to the plan shortly. But this process is potentially quite long, but it may not necessarily be, and I'll explain that in a second. But effectively, the process is built up into two key areas. There's a 20 business day area and then a 15 business day area. So with this 20 business day area, now what I want you to think about is that there's a lot of things that can happen in 20 business days, as you can no doubt appreciate, particularly when you're trying to run a business. You've got employees to look after, you've got creditors chasing you for your payments. So effectively what the government has done is that they've said, look, once you start the process, no creditors can take you to court other than from court approval, and no one can enforce a personal guarantee against you. Now, what will effectively happen, and this is still certainly, we'll wait and see, but effectively what would happen is that the practitioner would get appointed at the start of the 20 business days, and then during that time, the control and the authority and pretty much everything, as long as it's within the ordinary course of business, is kept with the director, the business owner. Okay, now during that 20 business days, it'll effectively be up to the director, the business owner, to negotiate with their creditors to allow them to keep trading, to make sure that they can keep getting supplies, that they can keep employing creditors. So I'm imagining before that 20 business days, there's probably going to be a bit of work done with your accountant or the restructuring practitioner themselves to just make sure that you're fine on a cash flow perspective. During that 20 business days, you'll be working on continuing business. You don't necessarily have to keep your business open, and I do want to stress that point. You could, in theory, just use this process to put forward an offer to your creditors for some other reason. There might be some tax benefits here for you, or there might be some physical assets that are worth money that should be distributed to creditors. So you don't necessarily have to trade a business, but I would say for a number of these businesses, they will want to keep trading. So you're gonna have to deal with all that. There's a lot of things there that you're gonna have to think through and appreciate, and that's something that you'll work really close with your practitioner. But at the same time, you also need to work on the plan. Now, I imagine that there's gonna be some people out there who are gonna wanna work on the plan even before they start the process, and I think that's a good idea. Because it might take a bit of time to actually develop. Like 20 business days from a business sense might be a long time, but when it comes to the putting together the plan and that, it might be a very short period of time, particularly if you've got really complicated affairs. So you've sort of got two dichotomies there of issues that you've got to deal with. So that's why you need to work really closely with your practitioner, who will be able to help you, who can give you consent on things that are outside the ordinary course. And what that means is, if you want to sell an asset that you don't normally sell, and the restructuring practitioner agrees with it, you can do that. And there's a number of other things that they can give you consent on. So that 20 business days can be really crucial and something that should be used to its full advantage. So we've just finished the 20 business days. The restructuring practitioner has filled out this form that ASIC is putting together, and that form is then sent to all of the creditors, which will give them information about what the plan is, what the potential returns could be to the creditors if they adopt that plan. And it should also have some information in there around, well, look, if you don't accept the plan, this is what you might otherwise get through a liquidation or some other process. So that information pack is going to be really critical for creditors to make an informed decision. Now, it's not going to be to the extent of a voluntary administration report. As some may appreciate, a voluntary administration's second report is extremely voluminous. It's a lot of pages and a lot of information provided to creditors, really there to give them an informed view of, look, if you adopt the V8 plan, then you may get X cents in the dollars, Whereas if you adopt a liquidation process, you may end up with nothing, or you may end up with some cents of the dollars. Now that's pretty much what's going to happen here with this plan, except you won't get anywhere near as much information. It won't go to too much details about what might actually come out in a liquidation, I'm imagining, from what I've read and what I've seen. But it should give you at least an idea of when you might actually get some money and what that return could look like. So really important that creditors review the information and ask as many questions as possible. That 15 business day window is your chance to ask as many questions as you want, to take issue with things, engage an expert to look at it. SV partners will certainly be there to assist anyone who wants someone to review those plans from somebody else. And I think that's going to be a really critical area to make sure that you're being given all the information that you deserve to receive and should get, so that you can make a decision as to whether or not this plan is actually being put together properly. Has it got all of the right information? And is it being reasonable? Because something that you've got to realize is that through the plan, in theory, the director could offer a 5-year period over which up to 5-year period, in which they can pay you back. So they could say, look, I'll put together $100,000 of assets. I have $500,000 in creditors, and that $100,000 is going to get paid to those 500 over a monthly basis for 5 years. It's really important that creditors try to work out whether or not that is a better outcome than what they would get in a liquidation. They need to understand where the $100,000 is coming from, because if that monies were otherwise available in a liquidation, it may not be in their best benefit to actually adopt the plan. So they've got 15 business days, and whether or not creditors are going to know about it immediately, if they're going to have the whole 15 business days, it's very hard for us to know at this point. But as soon as you get the notification, it's so important that you reach out and talk to a practitioner. But what you'll basically be asked to do is, within the 15 business days, you'll be asked 2 things. 1, do you accept or reject the plan? And number 2, do you agree with the amount of debt that you're being informed that's owed to you by the company? So if you don't agree with it, then you have a full right to say, no, sorry practitioner, sorry director, you've put in the wrong amount of debt for me, I'm owed this. And so that will obviously then change how much of the dividend cents in the return calculation would come out as. So once you've submitted that and you've said yes or no, then what the practitioner does is they pull all the answers together, and they then count them. Okay, now it's not majority in number, it's not a split between various different calculations, it's literally just majority in dollar value. Now that's really important, because it basically says whichever creditors are owed the most, and if there's enough of them pulled together, then in theory they're the ones that are going to have control over the plan. So what I would add just quickly to that is that the related parties cannot vote on that process, which is a really important integrity measure to make sure that directors and that can't just stack the votes. So that's a little bit about the 15 business days, and I'll shortly be talking about the plan, what that might look like, and then a little bit about the restructuring practitioner themselves.